Well, good afternoon, everybody. My name is Lee Schwartz, and I'd like to welcome you to the first webinar in our 2024 Veterinary series. This one's titled Avoiding Pitfalls, DVM Contracts and Non-Competes in a Nutshell. We're excited to bring another year of interesting topics to you, and we'd encourage you to sign up for the other webinars in this series. I'll have more information on those at the end. Now, before we get started, I want to take a second and just say a few words about SVA and our history with veterinarians. Like many of you, we got to where we are by being independent, and our vision moving forward is to remain that way and continue serving the same clients we have since 1974. And a huge part of that client base over these last now 50 years has been within our healthcare practice, which includes medical, dental, and of course, vet practices. Our mindset is that when you're a practice owner or shareholder, you have to work with someone who's more than just an accountant or tax preparer. You need someone who's a true advisor working collaboratively with you. This webinar and others like it are just one small way in which we do that. As far as this webinar goes, please send in any questions you have as we go, but we'll most likely wait until the end to answer those. If you're a client and your question doesn't get answered, please reach out to your SVA contact. And if you're not a client but still have questions, reach out to me and I'll make sure one of our subject matter experts gets your questions answered. So let me introduce our speakers. We've got Stephen A. DiTullio. Stephen is an attorney and partner with DeWitt LLP. DeWitt has 130 attorneys and offices in Madison, Milwaukee, Green Bay, and Minneapolis. Steve helps clients with employment law compliance issues and defends businesses in litigation. He works with a wide range of clients, including trucking companies, manufacturers, bovine insemination companies, of course, and veterinary practices. On the SVA side, we have Andy Slinger and Nate Drykosen. Both Andy and Nate are principals in our healthcare group and have been leading our work with veterinary practice groups for several years. They work with practice owners and practice managers on growth, profitability, compensation, and tax strategies. So without further ado, Steve, I'm going to let you take it from here.
Thank you, Lee, and good afternoon, everybody. Happy to be here and joining with SVA in doing this series of monthly presentations over the next few months, which Lee, like he said, will give you more information about at the end of the presentations. So I'm going to start with the non-compete, and it's been a very busy year for issues related to non-competes. And I know this is a little bit of background for some of you, but it's always good to make sure we're all on the same page when you understand when I'm talking about the FTC's final non-compete clause rule. So this was a bit unusual in the non-compete world up until the FTC issued its announcement about this rule that was to become effective September 4th. The area of non-competes and restrictive covenants were largely in the realm of state law, other than protecting trade secrets, which has a federal law component. The federal government basically said each state should address these issues, and indeed, we do have state laws, which I'll be talking about in a few moments. But the FTC decided that it wanted to enter the realm of non-competes, and they issued this rule on April 23rd. It became published in the Federal Register soon thereafter with an effective date of September 4th. Now, that final rule has since been blocked by a federal court down in Texas. Nonetheless, it's still possible that this FTC rule at some point could go into effect. Maybe it's unlikely given the decision by the Texas federal court and subsequent appeals that are likely, but it's still possible. And if nothing else, it shows where the federal government was coming from regarding non-competes, and there may be renewed efforts as we go into 2025 to get maybe a scaled down version by a different agency or something of that type coming out. So being aware of what was in the FTC's proposed rule, which is now up on appeal, it's still important that all of you understand it. So in a nutshell, the final rule would have prohibited any non-compete clause in the entire country, with just a couple of exceptions, which let's go to the next slide to talk about the exceptions. By the way, it would not have affected any non-competes that were in place at the time of enactment, September 4th. But again, at this point, all of your current non-competes that you have written with current or former employees, those continue. So there were a couple of exceptions under the final rule. One was for senior executives, very, very minimal type of exception. Employees had to make at least $151,164 or more, and they truly had to have senior type positions, CFO, CEO, director, senior manager, something in that realm. You could have a salesperson, for example, who does not get involved in like policy decisions and governance of a company, but they are well in excess of 151,000. This would have applied to them because they would not have been considered senior executives. It would not apply if there was a sale of a business, so a non-compete in that type of a situation, that would continue. And you could also enforce non-competes if the cause of action accrued prior to the effective date of the final rule. That would not have changed in any way. Then there were a couple of other items. So let's go to the next slide. There was a requirement that would have had to occur before or by September 4th for employers that had non-competes, that would have had to send out notices to current and former employees who were under non-competes. That would have had to have occurred. But again, due to the Texas federal court's action, that is no longer a requirement. And the final rule, although this went back and forth with the FTC when they were developing the rule as to whether things like non-disclosures or non-solicitations would be included. So it turned out that when the final rule did come out from the FTC, it did not explicitly ban non-disclosures or non-solicitation agreements of any type. However, and this is an important however, it did recognize that if an employer tried to maybe get overly broad with a non-disclosure, non-solicitation, so that effectively was a non-compete, then it could have been prohibited. So with that, litigation began, and let's turn to what happened with the litigation in brief. So there was a legal challenge filed, actually a couple of them in Pennsylvania and Texas. It's the Texas one that got all the attention because on August 20th, the federal court in Texas issued a nationwide injunction blocking the FTC's rule from taking effect on the basis that it was unconstitutional. So that FTC rule with all of the provisions that I just talked about is right now on hold and may indefinitely be on hold or permanently on hold. Although again, maybe a different agency tries a different track that has some of those issues. So let's see. We anticipate that there will be an appeal by the FTC to the Fifth Circuit and likely to the U.S. Supreme Court, but don't anticipate the final rule in its current form will probably ever go into effect. It will take years of litigation at the appellate level, and likely the injunction will continue in place throughout the appeals process, although it is possible that an appellate court could withdraw or modify the injunction, but that's unlikely to happen too. So given that the FTC's rule is now on hold, what does that mean for employers, veterinary clinics, veterinary hospitals, and your practices throughout Wisconsin, and frankly, throughout the country? But what it means is we're back to where we were before April when the FTC issued its notice that the rule would take effect September 4th, which means we're back to looking to state law. And if you are a veterinary practice, a clinic, a hospital that is only doing business in the state of Wisconsin, you need to look at Wisconsin Statute 103.465, which some of you may be familiar with. This is the statute that has been in existence in Wisconsin since 1957, and the courts have actively enforced 103.465 and oftentimes have struck down non-competes that were considered overly broad and therefore unenforceable. The language I have up on the slide, I'm not going to read it word for word, is the statute itself, the quoted language beginning with restrictive covenants and employment contracts. That is Wisconsin Statute 103.465. And I have highlighted language that I will read right now, that they're enforceable only if the restrictions imposed are reasonably necessary for the protection of the employer or principal. And whether or not they are reasonably necessary involves a number of interpretations, which let's turn to those now. Let's skip this one. Okay. The restrictions must be reasonable as to time, and that's not more than 2 years in Wisconsin. If you look at your non-compete that you have written for your employees and it says anything more than 2 years, I can tell you almost point blank, it will be ruled unenforceable by courts that look at that. Territory. Some veterinary clinics that I work with or that have reviewed their non-competes, they still use a territorial restriction. There's pros and cons of doing that. You don't need to use a territorial restriction, and I'll get into more of that later. I think Nate might have some thoughts on that as well. Nate, you want to chip in on that?
Yeah, I would share that, quite commonly, many folks that come to us from an advisory perspective, they come to us with associate agreements typically in place where they have a non-compete that is set up based on a specific mileage radius. And coincidentally, the most common number we see, regardless of practice location, size, patient demographic, is 20 miles. So I'd be curious to get your thoughts on having kind of this maybe more traditional, almost kind of boilerplate mileage range and how that might apply, how the courts might see that, in actual, if any one of these are actually reviewed.
Yeah, that's a great question, Nate. So I'm glad you brought it up. So not only do I advise clients about what should be included or not included in a non-compete, but I also litigate this issue when it comes up. And I will tell you that courts will look very carefully at a territorial restriction. And they're not just going to accept that 20 miles is reasonable. They are going to expect the employer to prove it. And one way to prove it is by showing that your patient list, your client list, is actually primarily within that 20-mile territorial limitation. So for example, if I were to take a look at your customer list, your client list, patient list, and 95% of them were within 10 miles rather than 20 miles, I will be advising you that you're probably going to lose in court, because what that would say to a judge is a reasonable territorial restriction for your practice would be 10 miles, not 20 miles. You would need to be able to show that the lion's share of your clients are located within 20 miles. And if they are not, a court is likely to strike that down. So the territorial one is a little bit dicey because, again, as Nate just indicated, a lot of times he'll see 20 miles just as a routine number that may be picked out of the air, but that is not necessarily what the practice actually involves. So if you use a territorial restriction, please, please, please make absolutely certain that it is actually consistent with your practice. Nate or Andy, any other comments on the territory part of this?
Well, Steve, I'd love to ask you one additional question.
Sure.
You've explained the situation, but for obviously since 1957 and probably for all of our careers here attending, the employer and the employee have played nicely. There have obviously been situations that have been remedied through litigation, but do you have any comment as an attorney on why now? Why, of all the times this could have come up, why is this challenge happening in this current date and time?
You mean with the FTC issuing its proposed rule? Great question. Great question, Andy. And I definitely have a view on that. I'm an attorney, I should, right? So from my standpoint, it's somewhat reflective, and I'll be talking about this in just a few minutes, of what's happening at the state level. Some of you may or may not be aware of this, but Minnesota just recently enacted a law that says non-competes are prohibited. And California has long had that as a rule. In fact, California non-solicitations are also prohibited. And then we also have a lot of states that are moving forward in significantly curtailing the use of non-competes. For example, Illinois and Colorado, just to name two, they actually have salary thresholds. So for Illinois, if you make less than $75,000 per year, you cannot be under a non-compete. If you make less than $45,000 a year, you cannot be under a non-solicitation. And other states have either considered prohibitions or limitations like that, Andy, or they have dabbled in making other types of limitations on the use of non-competes. So that's a long-winded way of saying it's somewhat reflective what the FTC did with what's happening around the country and looking very closely at the basically restrictions, or the FTC calls it a restraint of trade on employees that occurred through non-competes. And it's somewhat consistent with what we're seeing in other states. My guess is over the next 3, 4, 5, 6 years, we're going to see more efforts by the states to enact limitations. And, maybe the federal government's role doesn't need to be as extensive as the FTC had proposed, but I think that's the sort of the environment that we're dealing in that led to that.
That makes sense. Thank you.
You bet. You bet. Okay, a couple other things just to be aware of with Wisconsin law. If we could go back a slide just for a moment. So there's something in the law called the blue pencil rule. A blue pencil rule, most states use this when it comes to non-competes or other restrictive covenants. And what it basically says is if a court thinks a rule is overly broad, or a non-compete or a non-disclosure or non-solicitation is overly broad, the court can pick up its pencil and basically modify the agreement through a courtroom proceeding. I think the blue pencil came about because a long time ago there was like copy paper that they would write it and change it, and the blue pencil terminology came about. Most states have that. Wisconsin does not. That's an important point. The second bullet point, if any part of the non-compete is invalid, the entire non-compete is unenforceable. So if your 20-mile territorial restriction is unenforceable, there goes the non-compete. Okay, so with that, now let's go to the next slide. Let's actually move on because I've already talked about the different states. So I want to make clear what a restrictive covenant is because I've used that phrase a number of times, and it covers a lot of things, not just non-competes, non-solicits of customers or clients, non-solicitations of potential clients and customers, non-solicitations of coworkers or employees, non-disclosure of confidential information or of trade secrets. Any or all of these, whether they are standalone agreements or combined into one, they are all restrictive covenants. And in Wisconsin, at least, that 103.465 statute applies to all of them. Okay, so then moving on to a couple other points about restrictive covenants that are important. The standard of reasonably necessary for the protection of employer. It's a very factual case-by-case analysis. So I can go to other cases in Wisconsin and advise clients as to what may or may not work based on case law. But, the factual circumstances can be very significant. In other words, you could have a territorial restriction of 20 miles that is absolutely fine and enforceable for certain veterinary practices, but not for other veterinary practices. So keep that in mind. And also, again, just be in mind that there will be no reforming of any type of restrictive covenants by blue penciling in the state of Wisconsin. So the standards that Wisconsin courts have applied, we've talked about a few of them. The restriction must be necessary for the protection of that particular employer. Reasonable time, reasonable territory, reasonable limit of contacts prohibited. That all of those things are standards that a judge is going to look at. And I always tell clients and potential clients, whenever you see the word reasonable in cases or in statutes, it means that there's more likelihood for litigation, because what's reasonable to one person might not be to another. The restriction must not be unreasonable as to the general public. So let me give you a really good example of that for veterinary practices. If you are a veterinary practice in a rural location with few veterinarians in that rural location, and that territorial restriction could impact the general public's access to veterinary services, a court can look at that and strike down a non-compete on that basis. Maybe that's a lot less likely to happen in a more urban or suburban area, but in a rural area, that's a real concern. So that's in the statute, that is something that is considered. The restriction must not be unduly harsh as to the employee. So that sort of goes into some of the other reasonable components. So let's go to the next slide. Covenants must have consideration. This is an absolute must. An offer of employment or continued employment now in Wisconsin is considered adequate consideration. It was really a question mark for many, many years in Wisconsin. And a lot of employers, and maybe your non-compete might reference some nominal consideration in addition to continued employment or an offer of employment. All that changed from the Wisconsin Supreme Court a few years ago. And now just continued employment is adequate consideration. You don't have to give an additional benefit, an additional monetary amount, anything of that type. And again, we're going to have a similar analysis for other restrictive covenants on consideration. So same thing with non-disclosures or non-solicitations. They must have consideration of some type, and continued employment is adequate. Okay. Nate or Andy, any other but before I go to you guys, I do want to just mention again, different states have different standards, and just be aware of that issue. Again, California is not the same as Wisconsin. Mississippi is not the same as Wisconsin. There are differences. So that being said, before we go on to talk about general employment agreements, Nate or Andy, any final comments, questions, things we should discuss?
Yeah, one kind of commonly occurring situation we see, as folks look to hire associate veterinarians, is oftentimes they're coming from a prior practice, which may or may not be from within Wisconsin. Say they're being hired in Wisconsin, or maybe from a national practice with a national presence to something based in Wisconsin. And often we see, when we look at their agreements, their non-compete agreements with their, or whatever restricted covenants they have with this associate looking to hire, there's sometimes language in there about what state some of the restrictions would be potentially litigated in. Any thoughts on that and how that might affect folks as they're trying to evaluate that situation?
Yep. Great question again, Nate. So there are numerous legal issues with that type of what is commonly called a choice of law provision, or it could also be a choice of law / choice of venue provision. Let's start with the choice of venue first. So if you have somebody that has relocated to Wisconsin and they had previously been working in Alabama, Florida, pick a state, under a non-compete, the likelihood that that person is going to be forced to go back to a state far away or even near is probably somewhat limited. Now, if the person is coming from, let's say, Illinois, and your practice is in Beloit, maybe that's a little bit different because you could have some competitive interests crossing state lines there. But a choice of venue provision is something that oftentimes courts want to, if somebody is a resident living and working in Wisconsin, they're not going to require them to litigate outside of Wisconsin. Now, choice of law is a little bit different, but I will, again, tell you that if somebody is living and working in Wisconsin and there is a choice of law provision for, let's say, Iowa or Nebraska, a Wisconsin court may, it depends on the judge, may analyze the non-compete under that law that is specified in the agreement that the new employee has signed with a prior employer. But it's also possible that the Wisconsin judge is going to analyze that non-compete under Wisconsin law, which is pretty strict. So it's a little bit of an it depends answer, Nate, but it's certainly possible that neither the choice of venue clause nor the choice of law clause would be enforced. Somewhat depends on the circumstances. Is somebody coming from a nearby state, a faraway state, like I said? Is somebody, a year and 11 months into their non-compete, or are they of a 2-year non-compete, or are they first month of it? Issues like that might come into play as well.
Yeah, that makes a lot of sense. Andy, any other comments or adds?
No, I think we're ready to move to this next section.
Okay, so I will kick off this next section, and then I will turn it over to Nate and or Andy for some more really specific, helpful content on this. Not that my content's not helpful, but mine is maybe a little bit more general in nature. So I do regularly prepare general employment agreements. So moving away from non-compete agreements or restrictive covenant agreements to a general employment agreement, which, by the way, might have a term that is a non-compete or a non-disclosure. But I regularly, routinely drop general employment agreements for clients or new clients, and some things to address or common elements that I see is whether it's a term contract or at will. It could be either, it could be a 1-year or 2-year term contract, but a lot of contracts, just because it's a contract doesn't mean it can't still reflect an employment at will term. So that's something that a practice has to decide. Some veterinary practices want the year or two, so there's a mutual commitment to the veterinarian staying with the veterinary practice, or maybe a practice manager staying with the veterinary practice. So that's a key issue, an element to think about. Obviously, the veterinarian duties should be set forth, whether that's in a attached position description or built into a term, doesn't matter, but the duties should be set forth. Whether it's full or part-time, some situations are just a part-time gig, and that's okay, but make sure that's reflected. Salary, incentive, bonus, compensation. I will stop on that just for a moment. That is a really important term to include if you want a bonus plan. Don't just have that as a verbal term between the practice and the veterinarian, because I can tell you that most of the wage claims that I handle fall under bonus compensation because it wasn't put to writing. And if it's not put to writing, it's gonna more likely to be litigated. If it's clear and set forth in written format, it's more likely to be easily enforceable and less likely to be susceptible to a legal challenge. So that is one. If you use bonuses or some type of incentive comp, make sure you have a written term on that. Also, common benefits addressed. continuing ed, paid vacation, paid sick days. What else? Let's go to the next. Malpractice insurance, other types of insurance. If you're going to issue a computer or a cell phone, have those as terms in the agreement. Employee provided items, sometimes work clothes or transportation, that's on the employee's nickel. Make sure that that is mentioned. Here's some other elements. Some we've talked about, again, like you can have non-disclosure of trade secrets or confidential information as a term in the agreement, or you could have a separate agreement on that. Same with if you do have a non-compete or a non-solicitation, that can be built into a general agreement, or it could be a standalone. Fee scheduling, handling of payments, what are the resignation, very, very important termination terms. Make sure that is part of your contract, that this is the entire agreement. Modifications, waivers. I mean, these are on, some of these are more standard legal boilerplate, like entire agreement, modifications and waivers, but some of them will be very particular to the veterinary practice. And I will just, I think this is my last slide. Keep in mind that along with the employment contract, if your practice has an employee handbook or just separate standalone employment policies that you want the veterinarian, or for that matter, a practice group manager to be under, I would mention that in the contract. And last couple of benefit retirement plans, if you have that, mention that. I think I talked about insurance, so I don't need to revisit that. And Nate, I can't remember if this slide is mine or yours. Is this one mine?
This one is mine.
Okay, then with that, I am going to go away. I may come back in a few minutes with a question or comment, but with that, I'll turn it over to you.
Thanks, Steve. Yes, we're definitely going to be looking to you to weigh in on some of this discussion for sure. So stepping back from a practice management perspective and kind of overall scopes of these agreements, and what are we trying to accomplish? And ultimately, in the perspective of both the owner and the employer, where everybody's striving to communicate fairness, completeness, clarity. And we spent a great deal today on compliance. And increasingly, we're seeing a lot more diverse agreements in place in the marketplace. And thought is that that's a product of a few things, but more and more people's lives are different, and the ways that they can commit to their career is different. Increasingly we see a lot more folks doing some sort of part-time, less than one FTE, especially in the veterinary world. And folks taking time, at least part of the days of their week, to take care of their kids, manage childcare obligations, those sorts of things. And increasingly, folks are looking for more and more ways to achieve their career goals, but still meet the needs of some of the clinic owners. So we're seeing a little bit more creativity, which is probably a good thing. But you definitely want to do so carefully for all of the compliance reasons that we talked about previously. You want this to be clear to your staff in terms of whoever you're contracting with, what exactly the expectations are. And of course, you want everybody to feel like they're getting a fair shake in all of this. So one of the first clauses that we often see as part of this contract construction, it's very relevant for what we've been seeing in the marketplace, is the exclusivity clause. And essentially, this is a statement, maybe a paragraph within the employment agreement with whomever you're contracting with. For example, we'll use an associate, since that's the most common. Are you going to allow them to moonlight at another practice? Are you going to allow them to do, say, 3 or 4 clinical days at your practice, maybe work at an urgent care on the weekends? Maybe they also have a standalone business that they also spend some time in. And some of that might be related to veterinary services. I can think of a great example here in the local Madison market of folks that have a very specific skill set, and they might have 3 or so clinical days a week where they're doing surgeries as an employee for a clinic, but then they might also be an independent contractor for other clinics. And what does that agreement look like? How does that, that's something you have to be comfortable with as an owner looking at building these things. Is that something you want this person doing? And then also what other agreements might you want in place if you are going to allow them to practice non-exclusive to your practice? Steve mentioned it before, but one of the next big areas that you definitely want some clarity is job description and duties. Thinking about expectations in terms of working hours, some of the less fun things about the nature of veterinary care, emergency care responsibilities, on-call duties, and overall scope of the practice. Think of the ambiguity that could exist if folks weren't sure if they had a regular on-call commitment overnights, or do I need to take this emergency call at whatever time at night? Am I the individual designated to do that? And the frustration it might cause if that is not communicated clearly up front. Definitely something you want to avoid, and probably has certainly contributed to some of these nuances, have certainly contributed to the more prevalent burnout in the veterinary world. Also looking at continuing education and continued development. This is something that commonly see with folks looking to continue to grow in their careers. But also, what are your expectations for them for maintaining their skills necessary for the job? And is there a role or extra or additional procedures, skill sets you'd like them to learn as part of coming into your practice? Is there an opportunity for growth for them? Laying those expectations forward up front can often be beneficial to communicate that to folks so they are clear and aware. We mentioned it before, but looking at compensation and benefits, it's usually composed of a few different aspects, obviously base salary or commission structure or production-based pay. So commonly we see this as like a pro-sal model is kind of the lingo that is commonly used, where there's some sort of base salary with a production-based true-up. Also want to be clear on whether or not there's going to be any kind of performance or sign-on bonuses, relocation assistance, any of the fringe benefits your clinic might offer. What expenses, if your employee incurs expenses, what is their burden for providing you with proof of those expenses, and what expenses are going to be eligible for reimbursement? That's something you definitely want to lay out up front, and can still take a little bit of coaching, because even as complete as you want to be, sometimes there is some gray areas that still emerge depending upon the type of expense. But trying to be as clear as possible is going to be your best friend in this case. And not so subtle plug about this is right now we're currently compiling our annual salary and benefits survey for the veterinary industry with a pretty good geography. And we're really excited for what those results might look like when that's completed. The collection period, I believe, is completed, and we're working on tabulating everything currently, but folks generally that have participated in that have found that very useful. So before we move on to bonuses and some of the more nuanced stuff, I wanted to check with Steve and Andy to see if you guys had anything to add.
I just have one quick comment on the relocation assistance. Or even the sign-on bonus would apply to both of those. And I can't remember, Nate, if you were going to cover this, so I apologize if I'm jumping the gun on it. But one thing to consider is if you pay those types of things to a new employee and they jump ship after a couple of months, have something in the contract that addresses that situation.
Yes, absolutely important.
Nate, what I'll add is I'm preaching to the choir here. I don't have to tell you all how competitive it is right now and how high in demand DVMs are in all areas, especially rural. So I really like how Nate had in there about carefully creative. I encourage you all to be unique as well and flexible. And one of my favorite lines is everything is negotiable. Okay. Yes, there's legalese that have to be in every contract, obviously, for the protection of both parties, but be flexible, be willing to negotiate and do what you need to do to recruit and retain those DVMs that are very high in demand right now.
Yes. And one thing before we move on to the sign-on bonuses and loan repayment, that looking through some of these benefits, depending upon how these are offered and structured, oftentimes some of these do end up falling under basically the same thing as taxable wages. Benefits can certainly be taxable fringe benefits, but one that to put on my tax hat here for about 5 seconds that we often see bungled is with relocation assistance. It used to be that you could give some sort of a moving allowance to folks in most cases, and under certain plans be able to exclude that from income. That's not the case now. Essentially, that is basically taxable wages. So you'll want to make sure that they are clear on that as well. And also making sure from a payroll perspective, if you're administrating your own payroll, that you've got that accounted for as well. So diving in a little bit on signing bonuses and loan repayment. These are two items that we've seen specific to compensation that have really trended up. I would say, Andy can correct me at some point if I'm wrong, I would say easily over the last 8 years or so. And that's been for a number of reasons, but mostly because of some of the, especially on the student loan side of things, some of the new laws that have come into place to help manage the national burden of student debt that's out there. You want to make sure that for any sign-on bonuses or any loan repayment assistance, you want to have some sort of conditions for repayment if they leave, like Steve mentioned. And one thing that is very tax efficient right now, so picking up my tax hat, putting it back on for another 5 seconds, through 2025, there's a very tax efficient way to help potentially your new associates pay for some of their existing student loans in a tax efficient way. And that's with an educational assistance program. And the way that works is through 2025, participants with those programs can make direct payments toward existing student loan balances for their employees. Now, there's some requirements of implementing a plan like that, and that could be probably its own webinar in itself. But just knowing that that's out there, it results in a great benefit for employers, and that payment is a tax deductible expense, and it's a payment made directly to a loan program or to a qualifying educational institution for qualifying expenses, is also sheltering the employee from tax on what is effectively earnings that's being rerouted directly to some of their cash outflows that exist in their life. So something definitely worth looking into if you've not already. Certainly an emerging topic that we see, especially with folks that are relatively new in practice, is a very defined mentorship program. Oftentimes it's desirable by many folks coming directly out of school. One of the most valuable, call it fringe benefits you can give them is your time and expertise. The environment right now is that folks are trying to get out a little bit faster than maybe they would have in maybe other iterations of curriculums, and they just don't have that practical clinical experience. And that is something that has existed for a while. It's not any kind of enlightening information I'm sharing with all of you, but it can really be beneficial to candidates looking to come to your clinic and be a great way to attract really folks that will kind of blossom into great practitioners for you in the future. So a few kind of key aspects as part of the mentoring program. First, you want to make sure if you've got a structured mentoring program or want to put that in an agreement, you certainly want to identify a mentor and also lay out the expectations of both the mentor and the mentee as part of that agreement. Some folks think of that as, obviously identifying a person, but thinking about the types of things that, maybe one of your more senior veterinarians could coach a new staff on, being that, cultural things about your practice specifically, or things related to, quality practicing overall, just helping them build that confidence. You'll want to think about setting parameters in terms of what does this look like in terms of their interactions between the two? Is that a set amount of hours per week? And how long does this mentoring relationship last? Is it going to be for the first 6 months and then we reevaluate things? Is it going to be for the first few weeks and then we reevaluate things? You want to make sure that everybody's clear on their expectations as a part of this process to get the best outcomes on both the mentee side and both the mentor side. You'll want to certainly outline topics, as I mentioned before. Is that coaching on how to communicate effectively with clients, having those delicate conversations? Is it coaching because they're interested in a little bit more of business management? Are you pulling back the curtain a little bit to let them see a little bit of the business side of veterinary care more so than just the clinical side? Obviously, medical skills fall into this, but certainly, increasingly personal well-being as well. If you've got folks on your team that are more tenured and are doing really well and happy about what they do, they've probably got some techniques and skills that have helped get them to where they are. And those types of skills are usually built over a larger amount of time in practice, and balancing that with life needs that quite simply someone directly out of school or new to the area is maybe not going to have a whole great grasp on. So some of those insights are going to be valuable to them. So ultimately, a great goal and a good documented byproduct of a mentoring relationship is oftentimes it improves the culture within your practice. It can actually lead to greater job satisfaction for both parties involved in the mentoring relationship, and has been proven to have some impact on reducing burnout, which is obviously a concern in the veterinary world.
What I would add to that, and I'll reiterate, this can set you apart. We're hearing more and more. Nate used the word confidence. It's intimidating. It can be overwhelming to come out of school, go into practice. And, for someone to know that you're going to be right by their side, guide them, develop them, be there, it sets you apart. And also, Nate's going to talk about it in a minute. It also is part of succession planning. If, it might be like, yeah, there's no way I'm going to own this place, or I don't have an interest. But over time, if you have that conversation the right way, delicately at the right time, it can lead to a succession plan.
It's a good point, Andy. And that's certainly something that, depending upon the life stage of whomever you're bringing into the team, that might not be a part of their first agreement with you. That might be, depending on the term, a few agreements down the road. It's definitely worth having that continued dialogue and conversation to make sure that you're helping fulfill their professional desires as well. So to circle back on some of the finer details for work hours and location, if you've got multiple clinics, one of them might be a bit of a distance from what many folks might call their home clinic, or maybe it's a dual location scenario. What is there a rotation for traveling between clinics? What are the expectations there? If it's fully mobile, you'll definitely want to set parameters on kind of what those days look like. So folks, obviously it's a very dynamic environment, but obviously folks can have some idea of their expectations and what's realistic. That will be a great help to them. Obviously want to make sure you communicate regular clinical hours, when to be in each day, and that might be before the doors actually open, and that might be after the doors actually close. But you want to make sure everybody's clear on that. After hours responsibilities, weekend work, and what exactly does the holiday schedule look like? Because those tend to be very sensitive times for folks, and understandably so. Andy touched on this earlier, but the opportunities for leadership and partnership down the line are certainly something that can be communicated in these contracts, and maybe not the first one. Is there an opportunity to someday buy into the practice, or be a partner in the practice? What does that look like? What's going to happen in terms of the transition? How do we go about figuring out what that value looks like? And what are your rights as an incoming owner, and what are we going to accomplish together? What are our obligations together supposed to look like? And beyond that, and maybe some might say a step below that, but from a developmental perspective, are there internal leadership opportunities below ownership that might be an option for some of these folks? Be that clinical directorship, or if you've got some task forces or committees within the office. Increasingly find folks like to have a lot of purpose in their roles as employees, and if there's opportunities like that might really interest them, that can be another great way to set yourself apart as an employer.
Nate, just one quick comment on that. I totally agree that is something that can and should be addressed, particularly maybe starting after the second contract or after a little bit of time has gone by. But I also want to caution folks to be very careful with that language. Don't overpromise. Don't go so far as to commit to something that you might not want to commit to quite yet. So I agree, address it, but have the extra language in there to protect the practice, just in case a decision is made not for that person to move forward into a leadership or partnership opportunity.
Certainly, certainly. And those timelines can change. That's the other thing is Steve kind of touched on that is maybe, you come into this and maybe one of your primary purposes for hiring someone in your practice is for succession, looking to develop them. Sometimes timelines change, making sure you've assessed your risk and manage that with the language is going to be important so that everybody is clear. And again, coming back to the clarity and fairness of these contracts. So some of the uglier parts of these can include dispute resolution and what happens upon termination and notice. So just thinking about, if we have a disagreement on this after the fact, how is it going to be handled at a basic level? We touched on this earlier, which state's laws will govern the agreement. I would say generally we see this only with practices that have presences in multiple states. Two examples that I can think of in practice, we've got that kind of Wisconsin, Minnesota, Iowa, Illinois state area. We've got practices, obviously, practices that are located right in the corners of those states. They might have team members living in those different states, might have, especially in the large animal side of things, you might have clients in the tax rule that we call nexus in a lot of those states. So just being mindful of having clarity on what's going to happen if we don't agree on this someday. Can really help keep your costs down and also avoid kind of the ugly breakups that are inevitable in today's kind of more litigious society. Lastly, termination and notice requirements. You'll want to make sure you've got, what are some reasons that conditions that would be cause for termination that for you, the employer of this contract, and what does that look like? Again, looking for clarity there. Whether that be for cause because of misconduct or some sort of breach in the contract, or if it would be without cause, be that just because business is slowed down. Maybe, again, an example on the large animal side, maybe you've got a large dairy or two within your practice base that ultimately sells, and there's just not the need for additional staff members. You want to have some provisions for that in there. Also, touching on what kind of notice period is required if that would be for resignation or termination. I would say in practice, and I'd let Steve comment on this too, as what might be more practical. I would say in practice, we've seen language that's anything from 2 weeks all the way up to maybe 90 days for someone a little bit more important, like where it might actually really impact business flows, like a shareholder or a highly performing veterinarian, to try and just give the business the best chance it can to try and retain the clients associated with that person that might be departing.
Yeah, I agree with that general time period. I will also say just on severance pay. Remember, severance pay is not a legal requirement in Wisconsin, or I think in any state for that matter. Whether or not you want to include a severance pay provision, that's something to give a lot of thought to. Might make sense in some circumstances, but in others, it might not. And Nate, can I also just mention one thing about the previous slide?
Yeah.
And this has to do with the mediation, litigation, arbitration part. So number one, I love mediation. So I definitely recommend, I'm with Nate on that. If you can avoid litigation or arbitration by mediating an issue, it's probably in everybody's best interest. My only comment on arbitration, which I've done a lot of arbitrations over the years, and I am a fan of it. I think it actually can be effective, but for purposes of contract preparation, it is a tricky term to include. There's a lot of legal requirements to have a binding arbitration term. You can't just put in the agreement, the parties agree, if mediation fails, to arbitrate any dispute. That's not going to cut it. That you need a lot more information about what body will be used to arbitrate. The American Arbitration Association, for example, who will pay for it, where it will take place, how many arbitrators will be involved, 1, 3, in an employment situation typically should be just one, not three. My only point is I agree with Nate about if you decide that you want to have arbitration as a term for resolving disputes, that is one that I almost would tell you, make sure you have an attorney look at that, because that can be tricky if you really want to have it enforced. Thanks.
Hmm. Yeah, and before we move on to questions, just be aware, like we mentioned earlier, we actually have an upcoming webinar on a little bit more about these specific topics, the termination and employee departures. It's called Risky Business, Avoid Legal Traps in Vet Clinic. We just circle back to the last slide, actually.
Sure.
Legal traps in vet clinic handbooks and termination. So some of this topic is actually going to be covered more in depth and coming on October 23rd.
Yes, we will talk about that some more in here in a second, but Steve, Nate, Andy, tons of great information. We're pushing up on the hour here, but I know we did have a couple of questions come in that I want to make sure we have a chance to address. So let me read these off. So the first question was, how does the current non-compete in Wisconsin apply or not apply to a contract with a relief vet service? This would apply if I were to attempt to hire a veterinarian from a national service providing relief work in Wisconsin and other locations.
That's probably for me.
I think so.
So a couple of just clarifications on that. If the relief vet is in Wisconsin, and there is a non-compete provision, that relief vet's contract has to comply with the Wisconsin non-compete. So if it's overly broad and unenforceable, that would probably make it a little bit easier. I think Roger sent this question in to potentially bring that person into your company. If it's a more limited, reasonable non-compete under Wisconsin law, it might make it impossible or very difficult to bring that relief vet in. However, if they are outside the state of Wisconsin, 103.465 won't in all likelihood apply in interpreting the relief veterinarian's contract with the national service if they have been, for example, practicing in New York or Ohio. It's sort of like what I said earlier, is that if the person is coming into the state, particularly if it's a nearby state, I think Wisconsin is probably more likely to interpret that non-compete under the other state's law, and whether or not it's enforceable will be dependent upon that state's law. If it's really a state that geographically is far away, maybe there's a little bit less tendency. But in a nutshell, if the relief vet is located in Wisconsin, 103.465 definitely applies as to whether that non-compete will be enforceable. If they're outside the state, it's a little bit of an it depends, but there's a reasonable likelihood that a judge will interpret that not under 103.465, but under whatever state law is identified in the non-compete.
Thanks, Steve. That's super helpful. And I know we had one or two other questions come in, but in the interest of time and knowing that people need to get back to patients and whatnot, I want to wrap up here. But Steve, Andy, Nate, as always, awesome information. As we wrap up, I just want to let everybody know you can go to svaccountants.com to sign up for the other webinars in this series. You can also find news and information that may affect your business. So Nate mentioned it, but our next webinar is October 23rd. The topic is Risky Business, Avoid Legal Traps in Vet Clinic Handbooks and Terminations. And yes, Steve will be back for that one. Thank you, Steve. And the one after that, I want to make sure everybody gets that on their calendar. That's November 12th. That's where we will review the results of our third annual veterinary salary and benefit survey. So I just want to remind everybody that the SVA team is only a phone call or an email away. So if you're a client, reach out to your SVA professional as questions arise. If you're not currently an SVA client, why not? But call me, Andy, Nate, any of us can get you the help or the answers that you may need. Thanks again for attending today. Hope to see you at our next webinars. We hope you enjoy the rest of your afternoon. Bye-bye.